Here's what I have to say about mediation. Timing is everything, I think, and then we'll see what you guys think. When should you do a mediation? When should you start thinking about a mediation? So let's talk about that. Is it ever too early to bring on a mediator? And we could let's talk about pre-litigated cases versus a case that is, in litigation early.
Well, first of all, every case is unique. So there really is no hard and fast rule from my perspective as to when to mediate a case. It depends on the particular case. Sometimes, mediating a case pre-litigation can be successful. A lot of it depends upon, if we're talking about a case where there's insurance coverage, whether or not the insurance company is in a position to evaluate the case.
And Greg, what do you think about that as far as when do we start that conversation about mediation?
Yeah, so generally, one of the phrases that I think is very on point is the right answer at the wrong time is the wrong answer. So it's all about timing, frankly. I think timing is one of the most important things. That said, what I say to people is I say, I don't call me, you call me. So the parties have some method to the madness as to why they are mediating at this particular moment. So it's a client-driven thing, like all things mediation, client-driven. But pre-litigation is interesting. I actually had a couple pre-litigation mediations this week. It just so happens. And the theme has been confirmed. It's all about information exchange, especially in pre-litigation where you don't have discovery done, you haven't taken depots, you haven't done any of the things that by definition extract information. The only way pre-litigation mediation works, I think, is if the plaintiffs, most of the folks, or hopefully all the folks in this room, as I understand it, are free-flowing with the info.
So let me jump in for a second.
Yeah.
And first of all, I don't mean to interrupt you, but I want to encourage the audience to send questions because somebody here, let's see, Bruce Berger says, great timing. I have a mediation tomorrow. So we're going to be talking about stuff. Yeah, exactly. So I agree with you. And I guess it really depends on the kind of case. So I had a case that was a wrongful death case. We knew early what the insurance policy was. There was no doubt about the coverage, like was there going to be other levels of coverage? Were there going to be other players? And it was a very tough case. And I knew emotionally for the family, it was too, they weren't even sure if they wanted to be a part of it. And I think they wanted just some closure very quickly to the litigation side of it because the other people were their friends.
Also, where there's going to be publicity on a case. I've mediated a number of cases where, particularly the defense didn't want to be in a litigated case.
That's right. And so the defense had reached out to me very early in that case and said, look, we want to get this thing done. Can we do this? And my position was the policy or nothing, but it needed to be, I think exactly. It needed to go through that process, I think, for the family and for the defense to get it. And that was just an example from me to get to the table early. But I mean, Alan, when you have a case that's a smaller case, maybe it's an auto case. I mean, don't you think, and Craig, you were saying this too, it's all about the information that you have because the treatment's not going to be done 6-7 months down the road. Those types of cases, I imagine, are going to be tough.
Well, there's another issue with smaller cases, and that is, the expense. So I see cases where you just can't afford to litigate them because of the expense involved, particularly here in Los Angeles. So getting a case, mediated pre-litigation can be very effective because you're putting more money in your client's pocket potentially. You're also, I think you're going to have a much happier client if they're getting paid early on in a situation where they brought a claim rather than years later. We're all seeing trial dates pushed out now, and that was a trend even before the pandemic, but obviously we're seeing that at light speed right now.
So we're going to have a whole COVID delay section to this discussion here today, which I'm sure is impacting everything. But Craig, what are your thoughts on earlier mediation with an auto case, perhaps, or an injury case where the treatment's still ongoing?
Yeah, so you said something that was really poignant in this kind of the story that you were talking about your clients is the timing is client driven, and it's client driven on both sides. Let's look at the plaintiffs. Maybe you have a client that just doesn't have the stomach or the wherewithal to deal with litigation. And I think it's important for you guys to really assess that right out of the chute. Other than that, even more simply, you might have clients that simply tell you, hey, you know what, I'm not into it for the long haul. So on your side, that's important as to the timing. Can your client withstand it? Do they want to withstand it? Also understand too, that on the defense side, the timing is carrier driven, presuming there's a carrier involved. Because to Alan's point, maybe it's a small case and they draw the conclusion they don't want to spend the money on it. So they reach out to you, who in turn reaches out to me as a group and suggest early mediation because they would rather, pay some money to Brian's client and close a file than pay some money to their defense lawyers to fight. So on both sides, the timing is client driven, and you really, as the lawyers, have to follow their lead.
So let's talk about this, because a lot of the cases that we hear here on case analysis, for the most part, are significant cases, and every lawyer hopes that their case is a big one with big coverage, with big injuries, with big damages, with futures, versus these small cases, because I don't think there's a lot of resistance from the crowd, and we'll talk about it, of course, about the smaller cases. We'll talk about those too, because I think those are more realistic. But in these catastrophic cases where you have 7-figure plus coverage, that's a completely different animal regarding timing. Thoughts?
Well, first of all, if you've got a case like that, you got to determine the coverage and find out if there's just a primary policy or if there's an excess policy as well. Because then you're dealing with, potentially more than one claims adjuster. Is the primary carrier going to tender to the excess carrier? I see situations where the plaintiff's lawyer is looking for money above the primary policy, and when I start doing my pre-mediation calls and whatnot, I discover that the excess carrier is not going to be involved. So going back to the timing, I think the mediator can help too. I mean, I make a point in every case to contact the lawyers ahead of time. And sometimes I'll tell the lawyers, look, this case is not ready for mediation. Let's push it back 2 months, or this is what you need to do, in order to get the case ready. I may learn things from talking to the defense about what they need, and then can go to the plaintiff's attorney and say, look, we're not going to have a meaningful mediation unless you've done this or that. I find, unfortunately, these days, lawyers don't communicate with each other the way they did when I was practicing. I used to say I had better relationships with my opposing counsel than I did with my own partners sometimes.
So let me jump in for a second, because I want to address this. This is from Joel Selleck. How important is the plaintiff's attorney's trust of the mediator? Well, I guess it's more of a question for me. Look, with Alan, I met him, 15 years ago, and I didn't know who he was, but I could tell that initially that he was different than most mediators. Same thing with Craig. I told you in the first 5 minutes of walking in this room, I knew I was dealing with a different type of mediator. And when I say that, because those of you who know me, I preach this improvisational approach to litigation. I also do feel the same way, especially about mediation. You cannot mediate from a script or a planned, we're going to do this and then they're going to do this. It just, for me, it doesn't work. And I think for these two gentlemen, they kind of do that too, whether they call it improvisational mediation or something else. I get that vibe from them, and that's why I was able to trust them early. yes, the answer is you have to trust the mediator. Do plaintiff attorneys hold back information and lie to the mediators? It happens all the time. But I found for me, when I'm doing that, they'll see through it if they're good. And most mediators are really great at reading people that are good ones. And that I'm gonna lose credibility with them when they find out information later. So that's just my approach, and I'll let Craig, because he's got some knowing nods going on, give us some mojo on trusting the mediator.
Yeah, so, 100% with an asterisk, highlight, anything to emphasize the point is that the plaintiff's attorney certainly has to trust the mediator. I have certain, and I'm sure Alan does too, I have certain plaintiff's lawyers that I've gotten to a point in trust with them where they actually ask me to negotiate the case, where they will simply say, hey, you know what? This is what I need money-wise, negotiate the case. Now, that makes me feel a tad uncomfortable, but it speaks to the level of trust. If they are going to trust me to go multitask or do something else or whatever and say, call me in 2 hours when it's done, that goes to show the continuum of trust you can build. I don't think the plaintiff's lawyers have to have necessarily that level of trust, but you got to be committed to the mediator that you've chosen. You have to dance with the one that brung you.
Well, let me ask you this, Craig. Assume I'm Joe Schmo, plaintiff attorney, and you already know information because you've gone into the other room and the defense has shared something with you confidentially that they believe is their silver bullet to the case. And then I say to you at the outright from the beginning, maybe in a private session outside of the client, or the client and I share it. Hey, listen, we have a problem on this case here. I had a second accident. I saw somebody mention in questions about there's a second accident, and the other side, we don't know if they know it or not, but we share that information, or we share that our client has gotten arrested or something, like whatever the issue is. How does that allow you to help the plaintiff side more if you're now feeling this information of trust versus you come in the room and I'm like, everything's fine, everything's peachy roses, and you've got this silver bullet. It may not be a big one, but you have that info. What do you think about that?
Yes, when it comes to information, more is always more. That's what I tell people. The more you're willing to give me, the more you're willing to trust me, the more you're willing to tell me about challenges to your case. I put that in the back of my mind. And of course, given confidentiality, I don't share it, but I know of it. So when I'm in the other room, my mind says to me, Brian's got challenges with his case. I got to try to help him maneuver this into a settlement posture sooner rather than later, so those challenges don't come to the forefront. If I don't know of it, if you don't trust me as much and I don't know of it, then I can't work with it in my mind in the other room. So when I'm advised of those challenges, or simply the ultimate challenge, hey, Craig, we don't want to try this case. Or, hey, Craig, the client says it's over today, no matter what. Those are the things that help me go in the other room and try to make it so.
Alan, I'm sure you've had a million examples over your career of this, but what are your thoughts about trusting and getting it, having the both sides, but particularly because we're addressing a plaintiff audience here, the plaintiff sharing information with you?
Well, I remember a call from you on a Friday with a trial on Monday telling me the client didn't want to try the case anymore.
Yeah.
That affected what I was doing with the defense.
Well, I mean, just in general, because look, I have a tremendous amount of trust with both of you, which is why I don't hold back. I tell you everything about my case so that you can.
Everybody's different. You and I have mediated a lot of cases together, so it's developed not only a trust, but also a kind of a cadence in terms of how we do things. But you're going to be in situations as a plaintiff's attorney where The mediator has been proposed by the defense, and there's kind of a thought that you want the defense to propose the mediator because they're going to be comfortable with that person. You're more likely to listen to them. I mean, it goes really for both sides, but you hear that all the time. So you may get before a mediator that you've never worked with before. Now, there's a way to deal with that ahead of time.
How?
Well, when I was litigating, there was no situation where I went into a mediation with a mediator that I didn't know without doing a lot of diligence with other lawyers, sometimes even other mediators.
Well, that's how I got to know both of you. You came suggested to me by Jeff Krivis, who was a mentor of yours, and everybody knows him to be like a guru of modern mediation. And Craig came directly from an attorney that I do a lot of trial work for. Like I end up trying the cases that they don't try, and they recommended Craig, and so I trusted them. That's why I went into that meeting already saying, dude, I know who you are. Please, I hope everything that they've said about you is true. And of course it was. So yeah, I mean, but let me throw this one out there. And I'm sure the audience feels this way because we don't always get the benefit of working with a mediator that we've worked with before. So when you're approaching a plaintiff attorney for the first time, Alan, I'll start with you. How do you build that rapport, that trust?
Well,
and then we'll talk about what goes on.
I start well in advance of the mediation. As a lawyer that I'm mediating a case for is not meeting me or talking to me for the first time when they walk into my office. So I start, building that trust, gaining that rapport ahead of time by calling the lawyers. I want to tell them basically what I'm looking for. I want to find out about the case. What am I going to need to prepare for it? The timing. So I don't think you look to build trust with your client or with the lawyer or adjuster who's ever appearing before you at the mediation. That should be done in, the process should start in advance. I think that, I'm very proactive in terms of reaching out to the lawyers, sometimes the claims people who are appearing before me. Not every mediator has that, they don't put that in their toolbox, they choose not to or whatever. So, if the mediator's not doing that, the lawyer should take the initiative and contact the mediator.
Well, I don't want to bash the big box mediation outfits out there that have, tons of mediators in their stable versus independent mediators like yourselves that probably have more freedom to do what you want to do as far as pre-mediation goes. But I cannot stand it when I go to the mediation and we've sent a brief or something, and I know that the mediator hasn't read it until they were drinking their coffee that morning. Craig, I mean, I know you're from the school of Alan because you've reached out to me before mediation began. I think at our very first one, you reached out to me, kind of like what Alan's saying. What are your thoughts on that? And then I want you to flip it to the defense side and tell me how you approach the defense, because I think everybody wants to know what's going on in the defense room.
Right. So Alan, I agree with Alan that at a minimum, the pre-mediation call is not optional as far as I'm concerned. It must happen. Now, mediations are client driven. So what I do, as you know, is I will reach out to each side and I will say, I would like to have a pre-mediation call with you. Would you like to do that?
And what are you investigating here? I'll put up a slide that you created that I think is helpful. 1 second, please. And here, I know that Dan wants me sharing the slides, not the slide from the other one. So here we go. Can you see it?
Yeah, that's kind of a little different topic though than answering the question that I think we're talking about. We're talking about building trust. I think the question is, how do I build trust with an attorney who I've never worked with before?
Okay, so go ahead.
Yeah, so it's with first the pre-mediation call or calls where you literally are getting to know them and giving them a chance to get to know you as a human being. We have to start at the very beginning. Hey, let's get to know each other as human beings. So that pre-mediation call is very important because that's your first attempt to get to know who you're dealing with and for them to get to know you. So 100% that pre-mediation call is important. Then when you get to the mediation itself, especially a first mediation with someone you've never worked with, you have to establish who you are, number one, and then be consistent in who you are. You have to be who they think you are, meaning that as you start the process and the hours go on, you have to do things you say you're going to. You have to keep promises. You have to do all those things that are very important at the very beginning, more so. I mean, they're always important, those things, but more so, I think, at the very beginning, because it's same stuff, first impressions. You never get a second chance.
So you guys know about my my improv for lawyers deal that I did on here with Dan, and we talked about it a tiny bit, but it's probably the most important part of what I teach about improvisation. It's a theory called status, meaning where people are in the hierarchy of the trial, the case, the negotiation. And so you're going to have, you know, big boss defense attorney or pipsqueak defense attorney associate in the room with claims adjuster versus you know, actual adjuster or representative of the company. And then on the plaintiff side, you know, you have the client's wife, or the client's husband, or the son. And then, of course, the lawyer who's banging on the table, or the lawyer who's got, you know, my office or one of Candace's office on speed dial waiting to call up. So let's talk about who the players are when you're setting up these first calls and mapping out what your mediation is going to be like.
Here, a suggestion. I think that dovetails right into a couple questions I'm looking at from a Mr. Arias and I'm not so sure it's an H. Lee, but if you look at those questions, they're very insightful and they both relate to how you're dealing with the insurance folks. And I think that kind of dovetails right into your asking, what you're asking. How do you maneuver the room?
Go ahead and feel free to read any question that speaks to you out on the list. So why don't you read it out loud so we know?
Yeah, try JE's first. This is a question.
Okay, so Mr. Arias, based on your experience currently in cases, early litigation, how is it going in the defense room? Adjuster calling shots, defense attorneys driving negotiations. What if insurance has in-house counsel? Can you talk about the defense room interaction experience? Now, yeah, Alan, you want to take the question and then, I'll come up.
I think there are a number of things to consider. You know, the practice has really changed significantly. I've noticed a big difference, let's say, in the last 5 years. When I was practicing, particularly when I was practicing defense work in the 90s, if I was representing carriers, they were much more interested in hearing from me and getting my analysis of the case and following my lead. That is totally flipped. I get many cases where the defense lawyers, even extremely experienced trial lawyers, are basically carrying a briefcase. So, you know, that's just changed it quite a bit. The claims people are much more controlling, you know, the playing field. And so you have to be aware of that dynamic. And there's a tension also. So let me give you one example. A lot of the carriers have gone to flat fee arrangements with their defense counsel.
What do you mean by that? Because
well,
not everybody knows about.
They're entering into an agreement with the defense firm that they will pay them a certain amount of money up front to litigate the case. And then there are various exceptions. So, you know, for example, you might exempt out a death case or something like that. But basically, you know, they may pay the defense firm, I don't know, $7,500 or $10,000 or whatever it is to litigate the case up to a certain point. from the law firm's perspective, they want to get that case settled as quickly as possible because they've already been paid. The carrier's got perhaps the opposite viewpoint. So you have to know that dynamic. I've had a number of cases where, I've gotten information from defense lawyers that have been very helpful in getting the case settled because they want to settle the case, and they're helping me get it settled because I've got perhaps a resistant adjuster. And that's where I can come into the picture and be persuasive. So that's something, to keep in mind. Knowing what the relationship is between the carrier and the defense counsel is important.
So how does in-house versus, pardon my term, outhouse counsel? Sorry, Craig.
Well, I think, okay, so the first issue there is, obviously, if you're in-house counsel, you're not billing. So oftentimes you'll hear adjusters saying, well, we're not paying for defense counsel. Now, my experience is that, my comeback is, yes, but you're paying for the building, you're paying for the infrastructure, you're paying for the support staff, and everything like that. Of course, the insurance industry flips back and forth on that. At a certain point, the attorney's fees, we're not paying them. Then they realize, oh, we've got all of this brick and mortar and infrastructure. That suddenly becomes important. So,
well, I'll tell you, I have Peter Diamond, who was a 27-year defense attorney for State Farm. And I asked him, what would they do for you when you would defense a case? Was there a party, a celebration, a bonus? He goes, no, they give me another file. And Craig, I know that you were a notorious dragon slayer as a defense attorney. What would they, I know maybe you had some carriers that would send you a box of pretzels or something, but generally, what was it like for them when you would win a case for them? I mean, what's going on in the defense?
Yeah, so let me build on Alan's point, and there's going to be certain points we make here today that I think are worth the price of admission for every plaintiff's lawyer on this call. So when we have one of those points, I'm really going to zero in on it, and here we are. The claims people control the room. The lawyers are pawns. Like Alan said, carrying the briefcase, messengers. Here's a quote from one of my former claims managers. Well, Craig, I appreciate the recommendations, but you surely don't think we're going to follow them, do you? What the point is defense lawyers, you wonder why your defense lawyer friends are all beat up, banged up, unhappy, looking like Eeyore, because that's what the industry on the defense side has relegated them to. You need to know that, because like Alan says, they're fighting the good fight, at least it looks that way, but they will help you. They will help you because oftentimes they're ticked off with their own adjuster, their boss, and you need to know that, and you need to know what that means in your room. So I can't emphasize enough that there's going to be points here today that go to the very heart of allowing you to draw back the curtain of what goes on in the defense room. And if you haven't been in that room, like a lot of plaintiffs' lawyers, those are the nuggets. That's what you want. You need the intel of that room. To Brian's point, Brian, hiring a guy like Peter Diamond or hiring any former defense guy or lady, I'm here to tell all you plaintiffs' lawyers out there that have firms or are in a hiring mode, do yourself a favor. Get yourself a mole.
I have another amazing attorney is Tim McCormick, who worked at Yoka's firm. And first of all, he's a great guy and one of the hardest working attorneys, but it's so good and important to have a defense orientation when you're initially looking at the case. And it really helps me because I'll bring them to a mediation with me so I can say, what the heck's going on in the other room?